Errors and omissions insurance, E&O coverage. What is it? What's it for? Why do you need it? Do you need it? The answer for the last question is, oh yes you do, if you're going to be in business. What's it for? Well, think of it as catastrophic loss insurance. If you do something and you screw it up, and your client is injured and you don't have the money to pay, your errors and omissions insurance coverage does. It protects you and helps you protect your client if you did something wrong. It's to protect against a claim that arises out of a negligent act, something you didn't mean to do, but it happened. Okay. Do you need it? Well, if you're in business today, I don't think it's prudent to not have it, because we're all human and we all screw up at one time or another. Just ask my wife. So how do you trigger a claim to your insurance company if you get a claim? Well, what's a claim to begin with? A claim is a demand for money as a result of services that you have provided. Now, that demand can be in the form of an email, it can be in the form of a letter from a client's lawyer, it can be in the form of a summons and complaint. Everybody thinks that a lawsuit is a claim, but nothing else is. That's wrong. It can even be a phone call. If there's a demand for money related to past services, that's a claim. You need to tender that claim. You need to deliver notice of that claim to your E&O carrier as quickly as possible. Now, tendering a claim to a carrier is important. You need to read the tendering provisions in your policy. The tender provision is going to be specific. It will not say, submit the claim to your E&O broker. Your broker is not your insurance company. You need to submit it exactly to whom and in what way the tender provision of your policy says. And don't wait, by the way, to tender a claim. We've all heard the phrase, no good deed goes unpunished. If you wait and try to fix the problem or work it out with a customer, you may work yourself right out of coverage. Some policies have a provision that require you to tender the claim within 30 days. Others say immediately upon notice of the claim. Most policies are called claims made and reported policies, which means if you have a policy that goes from January 1st to December 31st, and you get that claim on Friday the 31st, you need to submit it Friday. Because if you don't and you submit it the following Monday, you're outside of the policy period, and the claim was made back on Friday, but not reported until Monday. Claims made and reported both have to occur within the policy period that you're talking about coverage for. So, don't wait. Another mistake we see a lot is there'll be letters and emails and stuff that comes into a brokerage that hasn't risen in the broker's mind to a claim. Well, what if you've got half a dozen of those things? You're a busy broker, you got a lot of agents, stuff happens. Your policy is going to expire in a week. Take out a piece of paper, take out your policy, look at where it says to submit the claims, and write down every single one of those 6. It's called a laundry list. It's the jargon term for it anyway. Submit that laundry list to your current E&O carrier before the policy expires, even if they never turn into a claim that actually has a lawsuit. By submitting those potential claims to your carrier within the policy period, you will have coverage for any of those that does turn into a claim. If you don't laundry list potential claims and it comes up in the next policy period, you'll have coverage denied. Be very careful. So, you've now received a claim and you have tendered it off to the insurance carrier. What's next? Well, the insurance carrier has a duty to investigate the potential claim and to decide whether or not there's coverage. The duty to defend is a pretty broad duty. So even if there's only one claim out of 17 that would give rise to coverage under the policy, the carrier has to defend all of those claims. Now, that's good for you. But what happens when there is that duty to defend? Do you get to pick your lawyer? Do you get to go to your brother, your cousin, your uncle who happens to be a lawyer? No, you don't. Generally speaking, what happens when an insurance carrier is going to give you a defense, they get to pick the lawyer that's going to do the defense. And that's called panel counsel. Panel counsel is because it's a list of lawyers who are on a panel that the insurance company uses all the time. In fact, most panel counsel have long-term, long-standing, and full employment agreements with the insurance companies. Panel counsel generally get almost 100% of their work for the insurance company that is assigning it claims. How come? Because panel counsel will sign what are called litigation management agreements. And those agreements restrict what panel counsel can do as it is defending a claim. So imagine your joy, you get the insurance company's panel counsel who has one arm tied behind his or her back and how they can manage the defense of your claim. Think of it like an HMO, and the insurance company gets to tell the doctor what test the doctor can run and pay for. You don't want that when it comes to either your doctor, and you certainly don't want it when it comes to your lawyer. Now, remember I said that not all claims are covered. What if you are one of those circumstances where one claim is and 16 aren't? You get a letter from the insurance company called a Reservation of Rights letter. And the Reservation of Rights letter is just that. It gives you notice that the insurance company is reserving its right to not pay a judgment under a claim. How come? Well, if you've been sued for negligence and fraud in California and in most other states, in fact, all other states, fraud is an intentional tort, and there is no way you can have insurance to cover a fraud claim. So the insurance company doesn't have to pay, it doesn't have to indemnify against a fraud claim, even if it has to defend against the fraud claim. It's a very important distinction. So if you've got this Reservation of Rights letter, what does it mean to you in terms of who you can pick to defend your claim? Because remember, you've got the insurance company's panel counsel who signed a litigation management agreement that is now your lawyer. The Reservation of Rights letter says, we might not pay everything. That creates a conflict of interest between you and the insurance company. So when you get that Reservations of Rights letter, here's what you can do. You can demand, most of the time, what's called cumulus counsel. Cumulus counsel is an independent lawyer. It's somebody you pick to defend your claim. It's somebody that understands professional negligence, someone who understands breach of fiduciary duty, someone who perhaps has been a real estate broker for 30 years and understands the business as well as the law of how you do everyday work. That's probably a better pick for independent cumulus counsel than the panel counsel person selected by the insurance company, who may do a lot of auto accident cases, but not so many breach of fiduciary duty cases. The good thing, the beautiful thing, the thing that should give you comfort when it comes to picking independent cumulus counsel is that even though it's your lawyer and you picked them, the insurance company pays the bill. And by the way, if they don't, you have a claim for bad faith against the insurance company. That Reservation of Rights letter is supposed to tell you about your right to pick independent counsel. And I'll challenge you to look through anybody's Reservation of Rights letters that have been issued in the last however long you want, and not one is going to tell you about your right to independent cumulus counsel. Think about that when you think about how well you think your insurance company and its hand-picked panel counsel is going to defend a claim made against you.